Welcome to meeting number 115 of the House of Commons Standing Committee on Citizenship and Immigration. And now we are going to the study of pension transferability and access to mandatory provident fund and delays in permanent residence and visas for Hong Kongers. Pursuant to Standing Order 1082 and the motion adopted by the committee on February the 12th, May the 1st, and June the 12th, 2024, the committee is resuming its study of pension transferability and access to mandatory provident fund and delays in permanent residence and visas for Hong Kongers. On behalf of the committee members, I would now like to welcome our witnesses for today's meeting, and I will start with the Department of Citizenship and Immigration, Director General, Family and Social Immigration Policy, Mr. James McNamee. Welcome. And from the Tax Treaties and Tax Legislation Division, we have Senior Director, Madam Stephanie Smith. Welcome. From Financial Sector Policy Branch, we have Senior Economist, Mr. Jeffrey Smith. Mr. Smith, welcome. And last but not the least, we have Director, Pensions Policy, Financial Crimes and Security Division, Ms. Kathleen Rai.
I would like to acknowledge that I am speaking to you today on the traditional and unceded lands of the Algonquin and Anishinaabe peoples. I would like to acknowledge that I am joined by my colleagues from the Department of Finance. Canada stands shoulder to shoulder with the people of Hong Kong, and we continue to monitor the situation as they navigate the impacts of the new Article 23 national security legislation. IRCC has also implemented special measures to allow individuals from Hong Kong to come to Canada with pathways to permanent residence. The demand for these pathways remain high. To help ensure that no one loses their status in Canada while waiting for a decision on their permanent resident application, a new public policy was launched on May 27, 2024, that will give most applicants to the permanent resident pathways an opportunity to obtain a new open work permit and remain in Canada while they'll await a decision. As mentioned in my previous appearance before the committee on June 5, 2024, IRCC is responsible for the issuance of Canadian permanent resident cards, which are intended to prove permanent resident status. Some individuals from Hong Kong are also using them as proof that they have left Hong Kong permanently. In March 2021, the Hong Kong government indicated that it would no longer recognize British national overseas BNO passports as identification. It appears that at the same time, individuals with PR card associated to their BNO passport were no longer able to access their pension funds. IRCC remains committed to taking action where possible to assist Hong Kong nationals in establishing themselves in Canada. Thank you again for the opportunity to join today. I welcome any questions you may have. Thank you.
The main questions we have here are your role, your department's role in finance in regulating a Canadian entity here, two Canadian entities, particularly Sun Life and Manulife, and how that regulation impacts when they've got foreign subsidiaries that are regulated by a separate entity. So it's that overarching regulatory authority where you're looking after how they behave in Canada with respect to people in Canada that might be permanent residents. Can you give us a little explanation about how you're overseeing the way you regulate these entities in Canada once they're dealing with people that are Canadians who've come here, in this case from Hong Kong, and can't access their Hong Kong pension?
There's no precedent for this situation within the financial regulatory framework. You can say that unequivocally.
So no precedent. I'm trying to. This is the second time you've been before this committee, Mr. Smith, and your colleagues. We're trying to see how you might be influencing decision makers here, particularly the minister, on the way the government deals with this situation regarding people who've come from Hong Kong that are trying to get their pensions moved over to Canada. Have you given any advice to any minister about how this should be dealt with?
Ms. Smith.
Thank you. No, we have not given any advice to the Minister of Finance on this issue. The operations...
Excuse me, I said any minister.
Pardon me for the lack of specificity. We have not given any recommendations to any ministers on this issue.
So your role here is overseeing the regulated entities, which are Canadian entities, correct?
Canadian and foreign entities operating within Canada, yes.
How you regulate Canadian companies that have contradictory regulatory requirements in foreign jurisdictions through their subsidiaries. Is there a way of getting through that morass and ensuring that those regulated Canadian entities fulfill the requirements to get Canadians, new Canadians in this case, the funds they're due from their retirement funds?
The foreign operations of Canadian financial institutions are subject to the laws and regulations of the foreign jurisdictions in which they operate. We don't have any authority to compel Canadian financial institutions operating in a foreign jurisdiction to disobey the laws of that foreign jurisdiction.
So when those Canadian entities are trying to get funds for Canadians, no matter where those Canadians come from a fund that exists elsewhere that they have put into, is that where your regulatory authority looks into their Canadian operations?
Sorry, our regulatory authority applies to their Canadian operations strictly.
So they're Canadians that are in Canada, and those are Canadians being served by, in this case, a Canadian registered company. And are those Canadian registered companies subject to Canadian laws about regulations about how they deal with Canadians who have put money in passports elsewhere? Is there any protection for those Canadians for getting their repatriated pension earnings back to Canada?
In this instance, no. We regulate the domestic operations of those financial institutions that are operating within Canada. As I previously noted, any Canadian financial institutions that are operating in a foreign jurisdiction must still comply with the laws and regulations of that foreign jurisdiction in which they operate.
Can you let us know if there's any way that you're involved in this situation at all? By involved, I would mean that you're providing any input or policy advice to any part of government regarding how this situation should be dealt with or ameliorated?
No, we are not involved in that respect.
Can you please tell us what respect you are involved in this matter?
We have met with Hong Kong Watch in the past, about a year ago, and we've met with the Canadian financial institutions in question. Those meetings had a common theme. We were trying to understand the issue a little bit better.
So your meetings with these people, did they lead to anything regarding a course of action that would fix the situation at hand?
There is no course of action under which the Department of Finance has any authority.
Thank you and welcome to our witnesses. My first question is for Mr. McNamee. Mr. McNamee, in your opinion, what are the specific challenges Hong Kongers who have a BNO passport are facing about the British withdrawal of Hong Kong when they come to Canada? I would say that the primary challenge is that the passport was not recognized for the access to pension funds in Hong Kong. So that's the number one challenge. After that, they're able to obtain the permanent residency pass card with this passport, and once they do, it is usable. I would say that the challenge is access to the Hong Kong pension fund. How is the department addressing this challenge? We are redoing the card for someone who prefers a new identification or passport, for example. If they have a Canadian passport a Hong Kong passport or a Chinese passport, they can exchange it for a permanent residency card to facilitate access to the pension fund. And in your opinion, is that easier? We have an open system for changing the permanent residency card. And we also have prepared the option to do so more efficiently if ever that's needed. My second question is for Ms. McNamee. What, in your opinion, are the initiatives underway to inform Hong Kongers in Canada of their rights and options when they are facing obstacles and problems, including access to their overseas assets? The question? Thank you for the question. We have information on our website where clients can find the information they need on how to get their permanent residency card. And we also have the option to undertake a communications process where we inform everyone of what is available to them. But we have also noted that some people have already changed their documents. And the documents for the moment the numbers are not large as we thought. And that means that we could do more to communicate to our clients that this option does exist to change their card for a permanent residency card. You said you could do more. Why aren't you? We know that the option exists, but our clients have asked for a certain number of them. But demand has not been growing since the issue arose a few years ago. Ms. Rai, were agreements or frameworks established to facilitate Hong Kongers' access to their mandatory provident fund, in particular for those who now have permanent residency or Canadian citizenship? Thank you, Mr. Chair, for the question. I will answer in English.
Claire,
very clear.
To confirm also, when you speak to an agreement, I'm just not familiar with speaking to, I can speak to federally regulated pension plans and how non-residency unlocking occurs here, but I'm not aware of any agreements in existence that would facilitate the unlocking of the MFP pension benefits.
Thank you very much. Mr. Chang.
Thank you, Mr. Chair. I had put a notice on Friday, my motion, which I would like to put in today, that upon the tabling of the supplementary estimate B for the fiscal year 2024-2025, the committee invites the Minister of Immigration, Refugee and Citizenship to testify on the supplementary estimates B by no later than the end of the current supply period. Thank you, Mr. Chair.
Thank you. So we have the witnesses in place. So what I have to take the orders and we have to debate this. Motion is in order, and I have MP Kwan. Please go ahead.
Thank you, Mr. Chair. Before we get into debate and or the next steps, could you clarify for me? Isn't it the practice of this committee to actually invite the minister for supplementary estimates? That is actually our regular practice. And we have actually been inviting the minister, no?
If everybody's in agreement, then we can...
I just need a clarification, because it is the practice of this committee to invite the minister. And we have been inviting the minister. And if the minister chooses not to attend, that is the reality of what this committee is faced with. So to move this motion, of course, is stating the obvious, because it is the practice of this committee to have the minister attend for supplementary estimates.
I would say that it's usually I mean, it's not necessary, but it's usually been, the practice going on here to have a motion bringing forward. So I would say that the motion is in order, and I'm going to go to the debate. If there's no debate, I'm going to take a vote. So
I just want to make a final comment. Just to say this, in many ways, I'm not going to oppose the motion. It's a redundant motion, is my point. And the point is that it is the practice of this committee, and it is a standing practice of this committee, to have the minister show up for supplementary estimates in a timely fashion. The fact that the minister doesn't is not because of this committee's lack of action, but rather the minister's refusal to show up. Just want to state that on the record.
And any more debate? Otherwise, we can take a vote. Mr. McLean.
Well, I'll second what Mrs. Kwan saying. And that is exactly the case. The minister has a responsibility to show up here. It's not a motion that can be voted up or down. He's got a responsibility to show up here to present his estimates to this committee so they can be forwarded to the House of Commons. I don't know why we have a redundant motion here.
Thank you, Mr. McLean. I will go to MP Zahid, then Mr. Chang.
Thank you, Chair. Yes, it has been the practice that the minister comes, but we have always passed a motion. Once the motion is passed, then the clerk sends out the invite, finds out the date which the minister can appear before the committee. So last 9 years, I think that's what the procedure we have followed through. So we have to pass a motion so that the clerk can send in the request. Thank you.
Thank you. MP Chang, you want to add something? No?
I'm good. Thank you.
You're good. Everybody's good, so we can take a vote. All in favor? Oh, wow. Looks like anyone opposed? None. Carried. So your time is up, Mr. Chang. And now we are going to my dear friend, Mr. Bruno Desap, for 6 minutes. Mr. Bruno Desap.
Good afternoon, everyone. On June 3rd, 2024, Eden Coverley, who is the co-founder of ConWatch and Hong Kong Watch, appeared before this committee, and he was prevented from. He was representing Hong Kongers in Canada who were unable to access their pension funds, and based on the research, over 80% of Hong Kongers have permanently moved to the UK and Canada, and they have had their pension transfer funds rejected. But in Sun Life in 2021, and the company rejected 1.2% of the some 14,000 requests received for not respecting the criteria or for minor administrative reasons. My question is not complicated. In your department, do you have the numbers for the withdrawals of the MPF, and for what reasons were they not made? We don't really have the numbers for refusals because those organizations hold the numbers, either Sun Life or other groups. Thank you, Mr. Chair. Are you in contact with these insurance companies? Answer, not directly. Not directly. We have indirect contact with them. We have had some contact with them to find out why this is happening, and according to them, the process, as my finance colleague said, is managed by the law that exists in the country of origin, and they are required to refuse these applications. Thank you, Mr. Speaker. Mr. Chair, rather. It is a bit strange. You just said that you don't have the numbers and that you don't necessarily have the reasons for the refusals. And to the following question, you said, yes, we have contact, indirect contact with them. So there is some contact. Did it ever occur to you to ask for those numbers from the insurance companies and therefore to ask for the reasons why for refusal from these companies, since you said you are in contact with them? Thank you for the question. I think that we need to find out more about why the situation is occurring. But we haven't really sought out all the details with them on these refusals because it falls under their field of responsibility. Thank you, Mr. Chair. I understand. So you were in contact with them. You're trying to understand why these refusals are occurring, but you haven't pushed farther. For us, it's difficult to understand because obviously we are doing business with people who are experiencing transnational repression. So what Hong Kong has established as a criterion for these people so that they cannot withdraw their money is indirectly using these companies, and therefore by also using the criteria of your department indirectly, you are participating. And I know it's not voluntarily, but are you aware that you are participating in a transnational repression by adjusting criteria and by not asking these companies to adjust their own criteria? I would say that we have chosen an option to help people have access to their pension funds by changing their permanent residency card information. And that is the control that we have over these cards. And sometimes people were refused because of the codes on the card. So the Department of Immigration would like to change its policy, but we can't really do exactly that to resolve this situation because we would have to change the codes, and we have the right to do that. That is our position. That is why we have done this for clients who wish to change their codes.
Now we will go to MP Kwan for 6 minutes. Please go ahead.
Thank you very much, Mr. Chair, and thank you to the officials for appearing before our committee today. In the opening statement, it was stated that the Government of Canada stands with the people of Hong Kong, and so there are special immigration measures that has been implemented, and the part of which was to extend the temporary status for Hong Kongers. Could the officials confirm that those who qualify under that program are provided with an open work permit and therefore LMIA is not required?
Mr. McNamee.
I would say that that's generally the case. If the work permit they obtained originally was connected to the public policy, that's correct. I don't know that in all cases that's the situation. In some cases, applicants may have had a LMIA-based work permit to begin with.
Right, but under the special immigration measure, the LMIA is not required. I have, however, a list of applicants in those circumstances whereby their work permit renewal application was rejected and they were asked to submit an LMIA, which makes no sense. And so I want to flag that as a deep concern because that is now emerging with people whose open work permit is being rejected. So you can imagine as they wait for their permanent resident status, and at this rate, given the immigration levels plan numbers and the processing delays that's happening, it's going to take, and then with a number of applicants in place, it's going to take something like 8 years to get through the backlog for people to be able to get their PR status, which means that if they're trying to get their pension, they will not be able to do so for 8 years because they are required to provide proof of permanent residency. So I want to flag this as a major concern, and I hope that the department will take action to fix the error that is being applied for applicants whose open work permit is being rejected under this stream. Can I get that confirmation from officials that that will be undertaken?
Mr. McNamee.
Yes, that issue has been raised with the department already, and we're looking into it to see what has exactly happened in those situations.
Okay, so the officials are aware of it, and yet it's still happening. I've got cases coming to me that's happening, and I'm about to prepare a giant pile of this stuff for the minister, so I hope that the officials will fix that. So now the other thing, of course, is that related to the pension is the fact that the lengthy delays for people to get their permanent status. Based on this immigration levels plan and the number of applicants that's in place, is it the officials' anticipation that it would take about 8 years to get those applications processed?
Mr. McNamee.
We have looked at that possibility. Certainly, it will take longer than we had previously indicated to the committee. But I would note that the first year of the levels plan is a fixed year. The years that follow, in this case 26 and 27, are flexible. So there are opportunities to adjust those numbers in the future, and that could affect that timeline. So it's hard to say whether 8 years will be the timeline, but it will be longer than had been originally predicted because the numbers have gone down.
What's the projection of the officials in the timeline that these applications would be processed?
Mr. McNamee.
Based on what has been tabled by way of the immigration levels plan?
So overall, because we don't break down the specific targets for specific subgroups within the H&C and public policy categories, our estimates would be that it would take 4 years for those applications to be processed. That was our base estimate. But you're correct that depending on where those numbers go, that could be longer or could be less. And I'm saying that only the first year of the plan is a fixed year, and plans can change and adjustments can be made.
Well, thank you very much. Yes, the government decided to table rolling 3-year immigration levels plan. And then, so those are the numbers that we're using, assuming that those are the numbers. Of course, subsequent times, perhaps even a change in government may well adjust all of those things. We don't know. But this is what we do know are the numbers that's before us. And based on my calculation, with the number of people that's applied, it's going to be a projected at least 8 years to get through the backlog. By the officials' calculation, is at least 4 years. So for people who's desperate to actually get resources, is it reasonable that they won't be able to apply for their pension funds for at least 4 years?
I think we acknowledge that that is a challenge. But so we're looking at what we can do to help facilitate and expedite that process. My apologies. The H&C category is oversubscribed. We have a lot of competing priorities, and it includes high priorities like other categories of people that we must process under the same space.
Well, thank you very much. Yes, there is a desperate need in the global context of people who are displaced and who are fleeing persecution. And Canada wants to claim that it's doing its part, but it's not doing it in an effective way for people. Is it feasible for people to be in limbo for years on end without knowing what their status is? And meanwhile, they run into problems with respect to application for jobs, with for students who are under student visa, their student fees is at least 5-6 times that of a domestic student. And then those who are trying to get their pension would not be able to do so for years on end. Is that a feasible way and a reasonable thing for the Canadian government then to say that they stand with the people of Hong Kong?
Thank you. The time is up, but I will give Mr. McNamee the opportunity to speak.
To that, I would say that the primary job of that public policy was to enable people to leave Hong Kong and find the safety of Canada. And I think by and large that has been achieved. People have been able to come here, obtain temporary status, and benefit from the protection of Canada. So from that score, I think it's been successful in doing so. Yes, there are challenges with the transition to permanent residence, but in light of what the purpose was originally, which was to take them away from a situation of risk, that has been delivered for the most part.
Thank you very much. And we will go to now Mr. Kmitch for 5 minutes.
Thank you, Chair.
Let me stop the watch. Okay, go ahead.
Mr. McNamee, first of all, on this PR card changes, I've never heard of this. When did this policy change?
I think from the outset, people have had the opportunity to modify their PR card with the submission of a new document, be a new passport.
I'm going to interrupt you. I'm going to do a lot of this rapid fire. Where did they submit that request?
We have information on our website to do that. It's a $50 process today, which we're looking to facilitate because of the situation.
Sorry, Chair, but you have to be much more specific. There are a lot of Hong Kongers watching this. So what is the form number? Where is it on the website?
I can provide that information to the committee. I don't have it here, but it is a standard process, one that doesn't happen frequently, but that we're looking to expedite.
Is this just for Hong Kongers, or anybody can request a PR change for that nationality code?
If they submit information regarding a new passport, yes, you can modify your PR card to reflect the new information.
And you're saying this has always been the case?
Yes.
Okay. That's new to me. How many requests of such changes have there been since the last committee meeting from Hong Kongers?
My understanding is the number has been quite small, and I can provide that information to the committee.
To the committee? When you do provide it, I would like to also know how many requests came in and how many were accepted for the change from the GBN to something else, because the source of the problem for BNO passport holders to Canada has been that's how the NPFA is able to identify a person who has left the country on a BNO passport. And you're saying this has always been the case. So fine, but we would like the information for the entire committee so then we can post it online, including the form, the precise form that is needed and where must it be sent, including an email, contact information, and a phone number. So the Hong Kongers who are coming to see MP Kwan, my office, and all of our offices stop doing that and go to see your department, because your department's inability to fulfill the requirements on time is causing all of them to inundate our offices with problems. I've gotten the same sheets that MP Kwan has of individual cases where they've been refused the renewals. You said during your introduction as well that a person has implied status. Is that implied status until the application is considered for PR?
Yes. Yes, an application submitted, the maintained status is retained until a decision.
So I have 2 letters here, 2 Hong Kongers, who says their implied status will expire 5 months after they apply. So this, I'm going to finish now. So it says here, please attach this letter to your present work permit number, and it's obviously a filled-in form, as proof that you're authorized to continue working under the same conditions as your original work permit until December 25th, 2024. Big Merry Christmas to them, I guess. And I have one here that was issued July 26th, and it says their temporary status will expire, and it says January 22nd, 2025. Based on your own testimony today, you've basically said that none of these people will get it within 5 months. The timeline for processing for their PRs can be up to 8 years. The way that's a number that MP Kwan has. That's because Hong Kongers are telling us this number. And if we use the target numbers that you have, it's 14 years. All these people will lose their implied status. So how could you have said to this committee that they do have implied status until their PR is processed, but the letters the department is issuing say the complete opposite, that they have merely 5 months?
Mr. McNamee.
I haven't seen one of those letters in a while, but I believe they also say, or until you have a decision. The faster of the two or something.
Whichever is first. That
Exactly.
means January 22nd, 2025 will come first if it's an 8-year timeline. That means December 25th, 2024. Merry Christmas to that person. It's an optician in my writing, and the husband will lose their jobs because they won't be allowed to work. Whichever comes first. Their wait time is 8 years, according to the testimony we've heard here.
Mr. McNamee.
I can tell you today that that's an error. That letter should not state that.
I have
You're correct.
hundreds of letters. So is this an error or is it a process issue?
Mr. McNamee.
It's a error in the wording of that letter. The regulations state that folks have maintained status until they receive a final decision on their application. Be it 1 year or 10, they have maintained status. That's the law. The letter states that, and we're looking to amend it.
I'm sorry, when it comes to legal, this is what the lawyers get, this is what immigration consultants get, this is what every MP office is getting right now. And it says very distinctly, or until decision is made on your application, whichever is first, and the timeline is always less than 8 years. So that if this is incorrect, your department's been sending out letters in the mail, hundreds and hundreds of letters. And there's 60,000 Hong Kongers here through this pathway program. So are you saying they're all getting a wrong letter?
Thank you. The time is up, but I will give the floor to Mr. McNamee to address those concerns and in the best interest of Hong Kongers.
I will say that when that letter was the form letter was originally created, we were within a much faster processing time. So that time, that date that was given in the future was many months in the future, and usually clients got a decision way ahead of that. In recent months, with delays, it's taking longer. So we've asked to amend that letter and remove that reference to make it clear that persons can retain status, maintain status until they get a decision, period. There's no limitation on that.
Thank you. And we will now go to MP Kaibaga for 5 minutes. Please go ahead.
Thank you, Mr. Chair. Through you, I would just like to maybe keep the conversation going on the letters that my colleague on the other side has. Can we just get an answer on how these letters that contain errors and incorrect information got out, and were you aware that these letters were being sent out?
The standard form letter has stated that for several years now, because it was a timeline that was well within our processing service standard for that type of application, or work permit, for example. In recent months, as that time has been exceeded, that date now sometimes arrives before a decision arrives. So we've taken measures in the department to modify that letter, hoping that that change can happen sooner than later, so that it doesn't state that anymore. But I just want to confirm that maintained status is maintained status, and it is valid until a decision is made, whenever that decision comes.
Can I just get you, through you, Mr. Chair, on the record, so the people who received those letters will be getting other letters with the correct information, and when will that be happening?
I'll come back to you on that, to the committee, exactly what the process will be, but we are modifying that letter.
Through the chair, your department is also tracking that there's hundreds of these letters out as well, and has the resources to be able to address this issue.
But I would note that many people get a decision before that timeline. In certain circumstances, they don't, but many do.
Thank you. I wanted to get to a finance question through you, Chair. From the finance perspective, your point of view on what your actual role is in all of this, and what is the core of the issue here regarding providing pensions benefits to Hong Kongers in Canada who have made claims.
Ms. Smith, can you speak closer to the mic because interpreters had a bit of a difficulty. So please go ahead.
Sorry, just to repeat, because through the chair, what is your perceived role?
Our perceived role in this issue, we regulate financial institutions on a domestic basis. We have no authority to compel those financial institutions to disobey the laws of the foreign jurisdictions in which their subsidiaries operate.
What, thank you, and through the chair again, what accountability measures exist to ensure that financial institutions like Manulife and Sun Life are actually representing their approval rates and following the fair practices?
Global Affairs Canada maintains the National Contact Point Office, which would be the appropriate point of contact for any groups or individuals who feel that Canadian firms operating abroad are not behaving responsibly.
Perhaps you can elaborate on how IRCC collaborates with Global Affairs Canada to address the concerns raised by Canadian residents and citizens about accessing their financial resources overseas.
I'm sorry, I think that question would be better directed at my colleague from IRCC.
You want to address?
Apologies, Chair. I missed the question.
Okay, I'll watch and I will ask honorable member to repeat the question.
Thank you, Chair. Through you, the question is, what is the collaboration between Global Affairs Canada and IRCC to address the concerns by Canadian residents and citizens in accessing their financial resources overseas?
Mr. McNamee.
We have been working with Global Affairs to look into this issue, and it's through this process that we were able to understand what was happening in terms of access or lack of access to those funds due to that change that happened in 2021. So we continue to work with them to see what can be done about that, and as a result, we've taken upon ourselves to look at a change in the card for those who can provide another passport as a solution that could help overcome that challenge in the short term.
Seconds.
Quickly, through another finance question through your chair. What is your role in monitoring the financial institutions' compliance with international standards and fair treatments of Canadians with PRs and citizens?
Mr. Smith.
It's my understanding that we don't have a specific role in monitoring Canadian financial institutions meeting their obligations within the HKSAR.
Thank you, MP Kaibaga. We will go to my dear friend Bruno Duceppe for 2.5 minutes. Please go ahead.
Perfect. Thank you, Mr. Chair. Perhaps I wasn't clear enough in my last round of questions. I don't want you to think that I'm picking on you. It's really not you, but what I think is that currently the authorities in Hong Kong are using the Canadian government and using Canadian insurance companies like Manulife and Sun Life to carry out transnational repression. I'm not saying at all that it's voluntary on your part. That's not what I'm saying. But I'm saying that currently, and I would like to know whether you're aware, that is my question. Are you aware, do you realize that through you and the insurance companies, the Hong Kong authorities are conducting transnational repression using you as a tool and the insurance companies? Do you realize that? Are you aware?
Mr. McNamee.
Thank you for the question. Well, I don't really have an answer to the question because it's a change that the government of Hong Kong made about the types of documents that... Mr. Chair, there are two ways to answer that question. Unfortunately, I cannot accept that that you don't have an answer to that question, because being aware or realizing something is a yes or a no. There is no, I don't know. Does your service realize that involuntarily you are participating in transnational repression by Hong Kong authorities? It can be no, or yes. It can't be I don't know. Mr. McNamee. Well, once again, I am unable to say whether or not I agree with that proposition, because it's not my role to have an opinion about this situation as a public servant. We have our regulations and our rules, and we try to do what we can within our own domain of responsibility. I understand, but thank you, Mr. Brunel Duceppe.
Now we will go to MP Kwan for two. This is the last honourable member before we switch to the next panel. So MP Kwan, 2.5 minutes.
Thank you very much, Mr. Chair. I just want to get back to these letters that has been issued to tell people that there's a deadline with their interim status. Will the officials be putting or issuing a public statement to let people know that this is an error? It's an old template that has been used where processing time used to be more expeditious, so that they're now not caught out in this situation thinking that their implied status would actually be expiring towards the end of the year. How will the officials fix this problem? Because I'm aware that some people went to apply for jobs, and then when they can only tell the employer that their implied status will only last a couple of years, that they were declined an offer of the position. The damage is already done.
I will take that back to the department to see exactly how we're going to proceed. As a first step, we are amending that letter.
Sorry, I get it. You're amending it going forward, but the letters already went out. The damage is already there. And the question is, what will the officials do to fix that problem for people? The other issue is, on the question around and to the letters that Mr. Kimmich has put on the record, I met with the Hong Kong Young Professional Association folks just this last break week, and literally scores of people came to tell me about the problems that they're faced with. And this is as a result of the government's failure to properly process their application and to expeditiously process their PR application. And then now this interim measure has created further problems for them. So this has to be fixed. It has to be fixed expeditiously. And then there's a question about what work needs to be done and what action will be taken by the officials retroactively for the people who has already been negatively impacted as a result of this error.
I would say that we'll take this back to the department and come back to you on an approach going forward.
I would, Mr. Chair, would we request officially that there be a formal response to the committee from the officials on this problem that we have identified, and to outline exactly the steps and the timeline of what those steps would look like to rectify this problem.
Thank you, MP Kwan. The time is up. On behalf of the committee members, I want to thank the panel members. Thank you for being here and sharing the information. Very best to you. And with that, I suspend until we get to the next panel.